Good afternoon, ladies and gentlemen. I'd like to welcome you to the Business and Utilities Subcommittee. Today is Wednesday, March the 19th, 2025. It's 3 p.m. I'd like to call this meeting to order. Madam Clerk, can you open the board, and members make sure to log into your device, and let's go ahead and take the roll. All right, Madam Clerk, can you go ahead and take the roll, please?
Mr. Chairman, you have 8 members present. You have a quorum.
Thank you, Madam Clerk. Members, before we get started, do we have any personal orders? I know I introduced her earlier today when in full commerce, but my sweet wife, Jada, is out there. Jada, if you'll wave at everybody, folks, if you'll make her feel welcome. And she is accompanied by a friend of mine from Lebanon, and that's Miss Helene Cash, if y'all will make her feel welcome, too. Do we have any other personal orders? If not, members, we do have a few housekeeping items. Item number 1, House Bill 569, has been taken off notice. Item number 2, that's House Bill 1047, has been rolled to the Hill. Item number 4, House Bill 1151, has been rolled to the final calendar of 2026 at the request of the sponsor. Item number 6, House Bill 648, has been taken off notice at the request of the sponsor. And item number 11, House Bill 978, has been taken off notice at the request of the sponsor. All right, members, that brings us to our calendar. And first up is going to be item number 3, and that is Representative Hawk. We have a motion. We have a second. Representative Hawk, I do not see any amendments, so you are recognized on your bill.
Thank you, Chairman and members. House Bill 965 encourages the use of construction apprentices enrolled throughout state certified programs and on state projects. We all realize there's a shortage of skilled workers in this field, and I would love to see some apprentices going forward. In a nutshell, that's what it is, Chairman and members.
Thank you, sponsor, for that explanation. Members, do we have any questions for the sponsor? If not, members, we're going to go ahead and vote on House Bill 965 to send it to full commerce. Madam Clerk, if you can open the board, and members, go ahead and cast your vote. Has every member voted? Does any member wish to change their vote? If not, Madam Clerk, take the vote, please.
Mr. Chairman, you have 8 ayes.
All right, sponsor, congratulations. House Bill 965 passes. It's on its way to full commerce. Yes, you're recognized.
Chairman, if I could, I hate the votes are gone. I want to take a picture. I've had 4 bills up and 4 bills rolled today, so that's the first one that has met with success. Cheers to my friend Rush. Thank you. Thank you, Chairman and members.
We were proud to be a part of that, Chairman Hawk. Thank you.
Oh, I can't forget them.
Members, that brings us to item number 5, House Bill 470 by Chairman Rudd. And Chairman Rudd, we have got some amendments.
Got one. We're applying that we worked with the State Department of Human Services to apply. It's 4890.
All right. Do you want to explain the amendment?
Yeah. Well, let me explain what we're doing. I'd have to explain the purpose of the bill to explain the amendment, whichever how you want me to do it. What this does, the amendment, like the bill's intention, they let me get over here. It's very simple on this. It says that if you're a member of an organization or a licensing department of the state, or if you're holding a professional license, the state cannot discriminate you for religious reasons, of course, as long as you're within federal law. And we've simplified this and eliminated working with the State Department so it wouldn't interfere with their licensing procedure, because they have certain, like child placement, they didn't want, the previous bill may have interfered with their accreditation of children's services, and they didn't want that to interfere, so we rewrote it to make them happy and try to please all the parties involved to protect everyone.
Okay. And Chairman Rudd, what we're going to do before we adopt any of the amendments, because we do have another amendment that Chairman Vaughn was bringing forth. So what we're going to do, there were some people that wanted to testify. So what we're going to do is go out of session and hear from them. I have Jim Lehman, Johanna Kehoe, and Aiden Pratt that are wanting to speak. So we're going to go out of session, members. And I will bring up Mr. Jim Lehman. Is Jim here? We'll have Jim come up first. And Jim, you will have 3 minutes to testify. Be sure to state your name for the record.
Thank you, Chairman and committee members. My name is Jim Lehman. I'm the Legislative Director for the Department of Children's Services. I think I just submitted a witness card as just to be available to speak. I didn't ask to speak. We had similar concerns to the Department of Human Services that the chairman mentioned, but we would follow probably the lead of the Department of Human Services and the other departments because our interests in the bill aren't unique to them, or at least from them. So with that, I'm happy to answer any questions you all may have, but I don't really have any statement on the bill or anything.
All righty. Thank you. Members, okay, Chairman Clemens, you're recognized.
What's the administration's opinion on the bill?
You're recognized, Jim.
I believe the position of the administration was working with sponsor to work out several of the issues that the chairman mentioned, but I believe everything is fine with the amendment. I'd have to defer to the Department of Human Services, who I think worked more on this bill than I did. So,
Okay. Thank you for that. Members, do we have any other questions for Mr. Lehman? If not, thank you for your testimony. And next up, we're going to have Johanna Keohane. And be sure to make sure we'll get your red light turned on and then you're live. State your name for the record and you'll be limited to 3 minutes.
My name is Johanna Keohane. I'm from Robertson County. Thank you, Chair, Committee, and Sponsor for allowing me to speak. Freedom of religion is at the very core of the founding of the United States of America, and I know you all know that. However, there are two sides to freedom of religion. There needs to be a balance between the freedom to practice one's own religion and the recognition that others may not be part of that same religion, and they have a right to freedom of religion just as much as the other. This bill sets the rights that are acknowledged to belong to all Americans against each other. On the one hand, freedom of religion, and the other hand, freedom from religion, as I understand it. I'd like to tell you a moment that happened to me. I was at work and saw a customer, so I approached to ask if she needed help. She did need help, not only to find what she was looking for, but she was feeling stressed and ended up telling me a long story about a family member of hers that had been traveling and had a medical emergency. Luckily, she had traveled to a state where one of the best hospitals for the emergency she was having was located and was now recovering. The woman told me she considered it a miracle, but her church elders did not approve of the use of the word miracle. I thought I was being helpful, and I told her I was a Catholic, and we believe very much in miracles. So I believed her when she said she believed that it was a miracle. She then told me, "It's not my place to say you're going to hell. Jesus will decide, but go find a real Christian and get baptized." That was not appropriate in any setting, let alone a professional setting, but it seems to me that this bill would protect that. Whose freedom of religion gets protected in this situation? Is her freedom to say what she did her deeply held beliefs, or my freedom to be a Catholic? It seems to me that this bill would prevent recourse for what she said to me because of her sincerely held religious beliefs or moral convictions. A large portion of the bill is focused on real estate, and I don't understand what is the practical application of this bill. I've bought a house, and I don't remember anyone's religious beliefs being a subject of the process. I don't know of any religion that has a belief of not housing people, so I don't understand how it comes up. Circling back to my story, I'm a Christian and she was a Christian, but for her I was the wrong type of Christian, and my concern is that this is the kind of behavior that this bill may inadvertently end up protecting. And if Christians can't even accept other Christians, what about someone of a different faith altogether, such as Judaism or Islam? Thank you for listening.
Thank you. We appreciate that. Members, do we have any questions for Ms.
Keohane.
Keohane?
Yeah.
Any questions? If not, thank you. We appreciate your testimony. And next up, we'd like to invite Mr. Aiden Pratt. And Aiden, just make sure your microphone is on. State your name for the record, and you'll have 3 minutes.
Hi, my name's Aiden. I'm from Wilson County. Thank you for the opportunity to testify in opposition to House Bill 470. Tennessee House Bill 470 seeks to allow professionals, including healthcare providers, business owners, and others in the service industry, to refuse service to individuals based on their professional religious beliefs. While the bill proposes to protect rights of individuals to practice their religion freely, it adamantly opens the door for discrimination against people based on their race, gender, sexual orientation, and other protected characteristics. Tennessee, like many other states, has established civil rights protections to ensure that individuals are treated fairly, regardless of their race, religion, gender, sexual orientation, or disability. By allowing professionals to refuse service based on religious beliefs, this bill undermines decades of progress in fighting discrimination. According to the U.S. Equal Employment Opportunity Commission, businesses and professionals are required to provide services without discrimination, and religious exemptions should be limited to avoid the harm of others' rights. This bill would provide a legal framework for discrimination, potentially allowing people to be denied service for arbitrary reasons, contrary to these core civil rights principles. One of the most significant concerns is the disproportionate impact this bill could have on the vulnerable populations. For instance, individuals who identify as LGBTQIA+ or people of color may face increased discrimination if service providers can simply cite their religious beliefs as a reason for refusal. A 2021 report by the Human Rights Campaign found that a significant portion of the LGBTQ+ community faces discrimination when accessing healthcare and other essential services. Allowing professionals to deny services based on religion could exacerbate this problem and contribute to a climate of exclusion and marginalized for these already vulnerable groups. By endorsing legal discrimination, this bill risks creating a business environment that is unwelcoming and divisive. Businesses in Tennessee particularly lose those in the service and healthcare industries could face a loss of customers, damages to their reputation, and potentially legal challenges. A study by the Williams Institute at UCLA found that discriminatory laws can significantly harm local economies by discouraging tourism, business investment, and even risk undermining its business environment by allowing laws that discriminate against people based on their identity or beliefs. Tennessee House bill could lead to a complex web of legal challenges that ultimately strain the court system. It could also create ethical dilemmas for professionals who may be forced to reconcile their personal religious beliefs with their professional obligations to treat all clients with equity and inclusion. For example, healthcare providers are bound by ethical guidelines, provide care without discrimination. Allowing religious exemptions for refusal of service could conflict with that duty of care. Healthcare professionals owe it to their patients. This contradictory could under.
Mr. Pratt, that's your 3 minutes, but I do have, I think, some questions for you. So if you'll stand by there. I first up have Mr. Representative Bricken. You recognized.
Thank you, Mr. Chairman. What we just heard is, in my opinion, a prime example of how misinformation gets started, and I just wanted to make that statement.
Do we have any other questions, members? We're out of session for Mr. Pratt. If not, Mr. Pratt, appreciate your testimony. And members, without objection, we're going to go back in session. And we are back on the bill. And Chairman Rudd, let's go ahead and get to those amendments now. And so the first one that we've got is drafting code 4890. Is that what you're showing?
Yes, that one would take care of, obviously they haven't read the original bill or the amendment. This is all dealing with actions outside of your profession that are within federal law. This bill plainly states that in a non-professional setting on the amendment, so you cannot be penalized as long as you're not breaking the law for anything you say or do in a non-professional setting. Your profession, your licensed profession is not covered by this law. You can abide by their code and their rules, but outside of your profession, you shouldn't be held accountable if you're not breaking the law. That's what the amendment does.
All right, members, you've heard the amendment. Do we have a motion and a second on the amendment? We have a motion. Do we have a second on the amendment? We have a second. Any questions specifically to the amendment? If not, we're voting to put amendment drafting code 4890 on House Bill 470. All in favor say aye. All opposed say no. The ayes have it. Sir, your bill is amended. That brings us to the next amendment, and that's drafting code 5150 by Chairman Vaughn. We have a motion. We have a second on the amendment. Chairman Vaughn, can you tell us about it?
Sure, and I've had conversations with the sponsor about this portion of his bill that I object to, and that is that in my issue it has to do with this requires, as my understanding of it, and if not, please someone correct me, is that this bill would require local boards of realtors to guarantee access to their multiple listing services to non-members. And my position on that is the first part of the bill doesn't concern me, and that's not my issue with this bill. But the fact that this bill is attempts to gain access, in my opinion, to the MLS systems by non-members, that's what I object to, and that's what this amendment would take care of. They would be deleting that section of the bill.
Okay. Chairman Rudd, you're recognized.
Obviously, Chairman Vaughn, you have not read the amendment that I negotiated with Human Services, MLS, and the Real Estate Board, and that's not mentioned in the bill now. This simply states that in a non-professional setting, it doesn't state anything about MLS. It states in a non-professional setting that a licensure or a certifying organization or a licensing body cannot discriminate in what you do outside the profession. It doesn't mention MLS or access to the MLS in the bill as amended.
Chairman Rudd, I think I see the problem here, and we're still on Chairman Vaughn's amendment, but I think your amendment that you brought forth, I think you're under the impression that it rewrites the bill. Is that correct?
It rewrites that section that I thought that you objected to.
Okay, so the rest of the bill still remains, and that's what Chairman Vaughn is seeking to address. And
well,
so
he's never got with me.
Chairman Rudd.
Okay.
Chairman Rudd. And so just to kind of let the members know that the bill is kind of divided into two parts, and the first part deals with membership in a real estate organization nationally. And it sort of ensures that the organization cannot discriminate against you for religious reasons or anything like that. And that's the bill that I think everybody in here is comfortable with. The second part of the bill actually says that you don't have to be a part of that organization in order to have access to the NMLS, but it goes a step further and says that you can't charge any extra for that. And I think that's a problem for a lot of real estate organizations is they have this proprietary model and access to the NMLS that's only available to agents or members of their organization, and that's what Chairman Vaughn is seeking to strike from the bill. So this will not impact the first part of the bill that deals with the religious discrimination. This just simply says that they can, in fact, require you to be a member to have access to membership benefits. Is that correct, Chairman Vaughn? You're recognized.
Excuse me. Yes, sir. That is my understanding.
Okay. So, members, you have the amendment before you, and so Chairman Clemens, you're recognized.
Yeah, thank you, Mr. Chairman. And I think it's as simple as the sponsor's amendment addressed Section 5303, and Mr. Chairman Vaughn's amendment addresses Section 5304. So there are two separate sections of the bill that are being amended here. So I don't know if both of them cover the stated purposes. It hasn't been misrepresented, but I think it's that clear.
Members, do we have any questions on the amendment that's before us? Chairman Bond, did you have anything else, Chairman Bond? You're recognized, Chairman Bond.
Thank you, Mr. Chairman. And I'll be happy to withdraw that amendment and just vote on the bill as amended. But this is a sticking point for me. I believe in protecting intellectual property of people, and we're not the ones that should be overturning that. Protecting freedom of religions of individuals and keeping them from a religious discrimination is something that I do value and I do want to protect, but that's just that's for the record.
Thank you, Mr. Chairman. So, members, let's go ahead and vote on this amendment. We're drafting on amendment draft.
Sir,
Chairman Rudd, you recognize.
I haven't seen the amendment. I'm being blindsided here. I haven't even read Chairman Vaughn's amendment.
Well, it does what he just described, Chairman Rudd. It just strips out that section that said that the organization had to give you access to the NMLS without charging a fee.
Let's read it. It may be a good amendment. I just hadn't had the opportunity to review it.
Chairman Rudd, we're going to go ahead and vote on that because you're not a part of the committee. Your opinion on it wouldn't matter in the vote. So, members, we're going to vote to put Amendment to Drafting Code 5150 on the bill. All in favor say aye. All opposed say no. The ayes have it. Your bill is amended, Chairman Rudd.
All right. Let me tell you what we're doing here, which is fine. It was my understanding it was going to be removed anyway. Let me tell you what brought about this bill. I'm a realtor, been one for 26 years. I've never had a complaint filed against me, luckily. And I've always tried to treat everyone, regardless of any of the circumstances, fairly. But on November 13th, 2020, the National Association of Realtors adopted a new politically motivated code of ethics that polices realtors' personal opinions outside of their profession. It states a realtor must not use harassing speech, hate speech, epithets, slurs, which has always been in our bill, based on race, based on color, religion, sex, disability, family status, national origin, sexual orientation, or gender identity outside of their profession. The terms are subjective and not adequately defined. Again, it applies to activities unrelated outside your profession. This violates a person's free speech and religious freedom. They can police this inside the profession, but outside the profession, as long as you're within federal law, you should be able to do what you want. These items left undefined beyond common language. This policy has proven problematic and left realtors around the country open to political retaliation and persecution by the NAR and their member association and their chapters. In 2021, Montana realtor Brandon Huber, who serves as a pastor, was disciplined by requiring diversity, equity, and inclusion training and fined $5,000 for an ad that his church ran regarding the LGBTQ agenda. The Montana legislature responded and passed protective legislation, HB 443. In 2021, Minnesota realtor Matt Moore wrote his association and posted on Twitter concerning his regards of the new NAR policy and could be used to violate members' free speech outside of their profession. He was harassed and later submitted in 2022. He decided to leave the profession because he could not practice his freedom of speech and talk about his values outside of his profession. In 2024, Virginia minister and realtor Wilson Faber was disciplined by his MAR association because he refused to denounce a 2015 Facebook posting of a Bible verse regarding marriage that he simply forwarded. He ran as a candidate for city council in 2023, and during that race, someone filed a complaint with the association when his forwarding that posting of a Bible verse was made aware of the public. The Virginia Association of Realtors ordered him to undergo re-education programming to rid him of his, quote, Bible convictions and to pay a fine. If he fails to do so, he could lose his membership in the Realtor Association. And under this discriminatory code of ethics regarding actions taken outside of your profession, a lawyer in court, a legislator presenting a bill, or someone having a conversation at a community event could be disciplined by their NAR association. This goes too far. I'm all for a code of ethics inside the association so that you treat all customers correctly, but what you say and do outside and your convictions outside of the association should not be held against you. These are just a few examples of realtors and what they face on an ongoing basis. Nearly all brokerages in Tennessee require you to be a member of an NAR associated association. And only through that will you be able to have association to what Chairman Vaughn mentioned, the multiple listing service. Without access to the multiple listing service, you cannot conduct business. And about 95% of all real estate companies want you to be a member of an NAR association. And now those associations, like in Alabama recently, that gave MLS's permission to allow non-members to have access to it, the NAR is now relieving them of their chapter status and going after the actual association now to remove them from the NAR. This has gone too far. The bill is amended. Both Chairman Vaughn and mine would both protect the realtor and protect the association from a retaliation from the NAR or any other organization and protect their freedoms to operate. And that's what the bill was brought for, and that's what it is meaning to do. Thank you.
Thank you, Chairman Rudd, for that explanation. Let's see. I have Chairman Clemens up first, it looks like. Chairman Clemens, you're recognized.
Thank you, Mr. Chairman. And so, I'm telling the realtors what they can and cannot do. I mean, we all support religious freedom. It's obviously enshrined in the Constitution of the United States and our state constitution. But, you could have somebody out there who represents the realtor brand, which has been invested in heavily. I mean, there's a lot of marketing. This is just hypothetical. wearing a realtor pin out there spouting Christo-fascist nonsense on the street corner. You don't think that the Realtors Association should be able to rein that individual in or protect their brand if they've got a member out there spouting Christo-fascist propaganda?
Chairman Rudd, you're recognized.
Well, there's always a limit to any free speech, and it depends on whether you're breaking federal law. Again, they're policing inside. Never before we started all this woke legislation a few years ago, never before has the association ever policed outside of their profession. They always have grounds to remove people for misconduct and for hurting other people or lawsuits or other legal action. But if we live in a free society, we can't punish people for being religious, for holding a view, for being a Democrat or Republican. It could just as easily be a conservative organization that controls an NAR association and retaliates against a liberal. We have to protect inside the association and make sure everyone has access to a home, everyone has access to seeing that home and filling out contracts, but they should not police what you do outside. That is up to society and the laws that we passed here to take care of.
Chairman Clemens, go ahead.
Thank you, Mr. Chairman. And I understand there are restrictions, time, manner, and place restrictions. Those are the identified exceptions to freedom of speech. Those are the general classifications for those. So, but if an individual, in my hypothetical, is on the street corner spouting Christo-fascist nonsense and wearing a realtor's T-shirt, I think the realtors should be able to try to protect their brand. And that, if they were doing that, they're not breaking the law. They're not, there's no violation of federal law or anything like that. So I just find it hard to accept that we're going to try to interfere with a private industry like that, trying to protect their brand. If somebody is spouting nonsense like that on their own time, and if it creates a threat to that entire industry and the brand that represents a whole bunch of people, and that individual is certainly known throughout the community as a member of that association, and people would identify their speech in that context with that association. That individual is not breaking any law, not doing anything, but I find it hard to believe that we are going to tell a private association how they can and cannot try to protect their brand. So that's one of my concerns with this. Thank you, Mr. Speaker.
Chairman Rudd, do you have anything on that?
No, other than this law, almost identical to it, was passed in Utah several years ago, and it served very well in protecting anyone. There's been no complaints in Utah.
Okay. Next up, we have Leader Cochran. You're recognized.
Thank you, Chairman. Chairman, and this is more just my ignorance of the industry, since I'm not a realtor. Just help me understand the nature of these organizations. Like, are they? I guess they're purely private, but would it be your argument that you can't do business without being a member of it? Just out of my ignorance, can you explain to me like the nature of those organizations? Private, voluntary, or you're saying that maybe if you weren't a member that you would not be able to effectively do business?
Chairman Rudd.
Well, realtors are a kind of a hybrid. They're independent contractors, which means they're self-employed, but at the same time, the state has mandated that they can't operate unless they go through a real estate brokerage to get their commission, so they can oversee them. And real estate brokerages, about 95%, require you to be a member of an NAR association because it comes with a lot of other benefits and guidelines and accreditation. You can be a real estate agent and not be a realtor, or be a realtor. The term realtor means you're associated with the NAR. A real estate agent does not go with that, but real estate agents do not have access to the MLS. Those are controlled by the real estate associations. So you can't do business without being a member of association in most cases, 95% of the time, especially in larger cities, and because you don't have access to all the services you need to provide your client. I'd have no idea of what's listed, what's sold, what's available to set up appointments. Most real estate agents that are not realtors are simply property managers and work for other realtors.
Leader Cochran.
I think that answers my question. I appreciate that. Thank you.
All right. Next up, we have Chairman Lafferty. Recognized.
Thank you, Mr. Chairman. I heard the explanation earlier. We've put the two amendments on. Let me see if I can repeat to you what I think we're doing here in the most simplistic terms. You're saying that if you are a member of this association, but you are outside in your own private time, not acting in any capacity associated with them, you can say and do what you want. The second part of it is that we will not allow somebody that's not a member of that organization to get access to our information free of charge. Is that oversimplistic? Am I?
Chairman Rudd, you recognize.
It was my understanding, both in the original bill and this bill, and especially in the bill as amended, that they can still free to charge a fee. We're saying that originally in the original bill that you had to be a member of the MLS. You couldn't refuse somebody to be a member of the MLS, but we didn't stipulate in there that it has to be free. I think with Chairman Vaughn's event, that clears that up and makes it very clear that they can charge a fee to be a member of the MLS. It's still up to them whether you're a member. My main concern is the association itself. And now that the NAR is actually retaliating against MLS, not MLS, but real estate associations that allow access to MLSs, this would also protect them, I feel. What's happening is that about 99% of an MLS's business is that local association. So they dictate the terms of how that business operates. While MLSs are not owned by associations, they're certainly controlled by them because that's their only real business partner. And they dictate that no non-realtor can have access to it. That's why you'll find that home inspectors, termite inspectors, builders, contractors join an MLS as an affiliate member so they can have access to the MLS. So, excuse me, I mean a real estate association. So they can have access to the MLS. So they go hand in hand, but the most important thing and the actions taken will be the association. And that's the main thing I'm addressing here is the association. MLS, certainly if you don't have access to MLS, even if you have to pay a reasonable fee, which all realtors do, they both are a member of the local association for several hundred a year, but they're also paid $45 a month to have access to the MLS. So in this case, I believe with Chairman Vaughn's amendment, we would both be happy. The real estate associations can't dictate outside your profession as long as you're within federal law, and the MLSs could charge a fee if Chairman Vaughn could explain his amendment better than I, but I believe that would make everyone happy and protect everyone.
Chairman Lafferty?
And just to our colleagues' conversation earlier, I'm not a realtor. I could put on a realtor T-shirt and jump up and down on the corner and act like a fool and still get that tagline. Anyway, just, all right, outside thoughts. Thanks. Thank you, Chair.
All right, members, do we have any other questions for the sponsor on his bill as amended? Leader Camper, go ahead. You recognized.
Thank you, Mr. Chairman. Mr. Chairman and members, forgive me for being late. I was presenting in another committee, and I missed part of the early deliberations before the amendments went on. Representative, earlier, I think the bill dealt with giving access to the MLS. In this amended version, both amendments went on, I'm presuming. Will people outside of the profession have access to this MLS, or will it only be the realtor memberships and the two organizations you kind of mentioned a minute ago?
Chairman Rudd.
You would have to, the amendment you gave me is not Chairman Vaughn's amendment.
Oh. Okay.
Not what he addressed, so I still haven't seen that, but according to his description, it would not require it, and but he can explain his second part of the bill, which I accept from his description.
Chairman Vaughn, how about it?
Yes. Thank you, Mr. Chairman. And Leader, the bill was divided into two separate kind of distinctive breaking points. What my amendment does is protect the ability of a local board of realtors to protect their who accesses their intellectual property, which is the multiple listing service. They have the choice of allowing it to open up. I know that Middle Tennessee is opening theirs up to people. You can pay $45 and shout out to RealTrax. You can join RealTrax and see how your neighborhood's trading. However, the Memphis area does not do that. You have to be a licensee and a member of their organization. When I started my career for 3 years, because I don't represent people in home transactions, but I do in business and commercial real estate. I wasn't a member of the MLS, so I didn't join the local association. But it's their right, just because you have a real estate license granted by the state of Tennessee and you're not a member, it's my position, and that was my amendment's position, that you should be able to dictate who has access to that product and who doesn't. And with the posture that we're in now, that is what is protected, and now we're dealing with the religious freedoms that the bill sponsor has talked about here in the last few minutes.
Leader Camper, you got anything?
Thank you, Chairman, for your explanation. So in your amendment on the religious freedom part of it, could you explain what that's doing?
Chairman Rudd, you recognized, and Leader Camper, I'm told you're not logged in up there if you want to do that when he's talking. Chairman Rudd, you recognized.
You know, what it does strictly in Chairman Camper, what it does strictly in a non-professional setting, the organization or the state cannot punish you or deny you membership or your license or your performance of your duties based on your comments you make of religion, of personal political views, etc., in a non-professional setting. They can still dictate that inside the profession, but not outside the profession. So that's what my amendment takes care of. So and that was only put on, I believe, in 2000. Let's see, that was originally put on the real estate, I believe it was in 2019. So that is what that does. It protects your religious freedom outside of your profession. Like I ran over, did you hear my description of members that had been discriminated against? Pastors, et cetera. It's ridiculous to me that if a pastor gets up in the pulpit and says, I don't know what example to use, let's just say the Bible says that it's homosexuality is a sin. He should not lose his real estate license what he preaches in the pulpit. Now, if he refuses access or service to a homosexual or transgender or anything, that's up, because he's acting as a realtor, that's up to him and the association to judge. But if he says it outside the profession and he hasn't broke civil rights laws, he hasn't broke federal law or state law, he shouldn't be punished or forced to take re-education training. That's what the two components of the bill does.
Leader Camper, you got anything?
I got it. I understand now. Thank you.
Representative Hardaway, you recognized.
Thank you, Chairman, and good afternoon to the sponsor. So, Chairman Vaughn's amendment within the context of the bill itself only deals with the MLS being able to control how they do business. Is that, and I know you said you hadn't read it yet, so I'm asking somebody, whether it's you or Chairman Vaughn.
Chairman Rudd, you recognized.
And please correct me, Chairman Vaughn, if I get this wrong. It's your amendment. You're the expert on it. But from what you've read, it's fine. No, it doesn't tell the MLS what they can or can't do. It actually frees them up. It says that they're not basically within the bill. The unique thing about a multiple listing service is there are a private company that a real estate association contracts to handle. They could just as easily contract another company to handle all their listings. So they contract this company to handle all the listings and all the data and the rental properties, the prices, square footage, all that. Load pictures up, et cetera, descriptions so people can see what's online. And so a real estate association has to have a multiple listing service. So this is saying two totally different things. One is dictating. The first part is talking about the real estate association and licensed professionals cannot be punished within the profession for what they do outside the profession within the law. The MLS is a separate company, and I believe Chairman Vaughn has said that we can't make that separate company accept members. Now, if the MLS, in order to do business with them in their contracts, which the MLS would be committing discrimination if they required in an agreement for the MLS to do this. But that still doesn't change the MLS as a private company, and they can do what they want. But if the the Real Estate Association forces the MLS to do something, that we're saying here they could be in violation by discriminating against their members. So the MLS is free to do what they want, but the association is the one we're holding accountable to a degree.
Representative Hardaway?
So does the MLS require state regulation, including licensure, to do business? And are we putting them in a different position or the same position that we are the realtors?
Chairman Rudd.
No, they do not. They're a private company that the MLS, which is a state, the association, which is certified and controls licensees, they are a association that has in part some state control and state dependence, but the MLS is not licensed by the state to my knowledge.
Representative Hardaway?
Well, that settles me on that. But the other part I want to ask about, would any of this bill apply to law enforcement?
Chairman Rudd.
Not to my knowledge. I don't know if law enforcement are state licensed. They're state trained and they're employed, but that would be outside of my purview. I don't know.
Chairman Bond, you recognized.
I appreciate that. This is my last comment, Mr. Chairman, because my friend from Shelby County had a question. At this point in time, the bill in its current posture does not deal with the multiple access to the multiple listing service. It's off the table with regards to this now. But one thing I would like to do is I would kind of like to say that the realtors are taking a beating on this bill, and they are kind of being singled out. One of the issues that I believe that this should apply across the board, to not just I would be probably, like I said, if this applied to more trade associations, and because it seems like we've unfairly targeted the Realtors Association because of this, and I know that the bill sponsor, he's the one that presented the bill, and he's got the research, and that's what motivated him to do it. But these are tenets that, to my thoughts, that any trade association should adhere to, allowing their members freedom of speech and freedom of religion outside the bounds of their organization. But I just wanted you to be clear that the bill in its current posture has the multiple listing service is not in play with regards to anything with this bill at this point in time.
All right. Representative Bricken, you recognized.
Question on the bill.
Questions being called. Without objection, members, we're voting to send House Bill 470 as amended to full commerce. Members, if you can place your vote. Madam Clerk, open the board. Has every member voted? Does any member wish to change the vote? If not, Madam Clerk, take the vote.
Mr. Chairman, you have 7 ayes, 3 nays.
All right. House Bill 470 passes. It's on its way to full commerce. Next up is item number 7. That's House Bill 469 by Representative Reeves. And Representative Reeves, I understand you did not need a motion or second on this. You were going to speak on it for a moment, so you are recognized. Go ahead.
Thank you, Mr. Chair. Yes, I'm enthusiastic about this bill, but recognize in this late hour that I probably need to amend it further, and I know we're late in the process, so I would ask that we roll this to the second calendar of 2026, if that's okay.
We will take care of that for you, and I want you to know I think you're on to a good idea here, and I think several members of the committee have expressed that as well. But at the 11th hour, members, we had some issues come up, and Representative Reeves did want to make some amendments, and we do not take untimely filed amendments in this committee. So, therefore, we will roll this bill, and that's House Bill 469 to the second calendar of 2026.
Thank you, Mr. Chair.
Yep. All right, members, that brings us to item number 8, and that's House Bill 1108. We have a motion, we have a second, and Representative Salinas, you are recognized on your bill.
Thank you, Chairman and committee. I'm here to present Bill 1108, and what the bill does is that it grants veterans, it waives business licenses for veterans that are opening their businesses. I know that we have several veterans that have signed on to the bill that are on the committee, but anytime that we can help as a community support the efforts that our veterans are putting forth, especially something that engages them in our economy, in our workforce, and in job creation, that we should support them in that. So with that, I stand ready for questions.
Okay, thank you for that explanation, Representative. And Leader Cochran, you are recognized.
Thank you, Chairman. And Representative Salinas, I think it is a good bill. I think anytime that we can take action to help veterans and especially to incentivize business development and employment for our veterans, I think it's a good idea. I think this is a unique way of doing it, maybe one that hasn't been looked at in the past. One question that I had as I was reading through it, just something that kind of jumped out at me. So Section F, where we talk about must not be charged for any veteran of the United States military, including the National Guard and Reserves. I think a lot of times when we do incentives for veterans or any type of legislation around veterans, we specify that it's honorably discharged. Do you know, does this bill, how does it speak to that? Could you?
Representative Salinas, you're recognized.
Thank you. Sorry. As it stands right now, it does not specify that, but I am open to amending and adding that so that it could be included for honorably discharged veterans.
Stand by just a minute there. We're going to, let's go out of session real quick and get a legal opinion on that and see if it can run as it is or if it does need to be honorable. So without objection, we are out of session. And we will go to Legal Services, and state your name for the record, please.
Levin Middleton, Office of Legal Services. So since the bill just says veteran, and from my understanding, you can be considered a veteran regardless of what discharge status you had, I do think that this could encompass veterans who were not honorably discharged. So if we wanted to specify only those who received that type of discharge, then I do think it would need to have clarifying language.
Okay, members, we're out of session right now with Legal Services. Does anybody have a question for our attorney? If not, we're going to go. Chairman Clemens, you're recognized.
Yeah, thank you, Mr. Chairman. I just wanted to make sure with the attorney, it is possible to amend a bill in that manner in the in the next committee, correct?
I believe that would be up to the committee, but it would be possible depending on what the committee would like to do.
In the full committee.
Chairman Clemens, you recognize.
We can amend it in the full committee.
Ms. Dunn, you recognized.
That is my understanding that there's no procedural issue with doing that. It would just be the committee's decision.
Thank you.
All right, members, we are out of session. Does anybody have a question for Legal Services? If not, we're going back into session. Leader Camper, you're recognized.
Thank you, Mr. Chairman. Thank you for the bill. I appreciate your passion and your willingness to work with Leader Cochran with his concern. And Mr. Chairman, I would hope that we could pass this out of here and then help her work with the language as it travels to full. And by the time we get to full, we have the amendment before us, and she could work with Leader Cochran on the language that would be good for all us to support. So she said she was willing to do it.
All right. Chairman Bond, you're recognized. Yeah, you're recognized.
Okay.
Recognized.
Oh, okay. Excuse me.
We're waiting on the microphone. So.
Okay. Yeah. I was kind of confused there for a moment. The only issue with doing it that way is that we also had one of our freshmen that just came in who had some, the previous representative had a bill that was also going to need some amending. And so what we did was we referred him back to the second meeting of next year. Great thing is it doesn't burn any of their bill space. So that would be what I would be proposing in this. But I have an actual question for the bill sponsor that if we're going to be amending it, I think I may have a question that we may need to include in it to where it's more than just the discharge status, if I may, Mr. Chairman.
Yeah, go ahead. Ask the question, Chairman.
Have you contemplated putting a cap on the number of license for the veterans, because it does not speak to it in your legislation. Is it just one business license per annum, 10 per lifetime? Is that something that you have thought about, or is it one of those things to where it just runs as is? It speaks to it to however they wanted to apply for it. And there's not a right or wrong answer. It's actually just a question of whether or not, what's your thought process on that?
Sponsor, you recognize.
Yeah, no, I haven't, but I think if our veterans are engaging in new businesses, I mean, it's only a $15 fee, so I can see where a problem could arise, but I haven't seen evidence of that as of right now.
Chairman Vaughn.
Thank you, sir. So to your, not meaning to put words in your mouth, but so your contemplation is if they wanted to do 7 or 8, that's cool. That's okay, because it's stirring economic activity. And that's a a perfectly reasonable position to take on it. So I was just curious as to if that would be a way that we could, as we look at perhaps amending this. But what I would say, Mr. Chairman, is that we was it the second week?
Yeah, what we did with the previous legislator that needed some amendments taken care of before full committee, he referred the bill. He asked that it be rolled to the second calendar of 2026.
In this case, also make that same motion.
Okay, that's a proper motion. Do we have a second? We have a second. How much objection do we have here? 3. All right. So we are voting on we have a motion before us. We have a second. We're about to vote on it, but actually we'll just let y'all talk for a little bit. Leader Camper, you're recognized.
Thank you, Mr. Chairman. I understand with the previous member, but his bill could have been a lot more complicated. So, it may take a year to get the language right. It may take more stakeholders coming to the table to make sure the language is right. I'm not sure that necessarily fits this case. This is two issues that I think could be resolved before, even if we hold it in this committee, which this is not our final calendar, that she'll have time to work through it over the next week and bring it back before this body this year. So sometimes, the bills, some bills are just a lot more complicated, and it may take, over the summer to get it done. But I'm just not seeing that that's the case with this bill. So I would hope that you would vote against taking that, a vote against that motion, and let us continue to allow her to get, the amendment right and bring it back before this body next week, since we are not on our final calendar.
We are on our final calendar.
It doesn't say final calendar.
Is the final calendar. Who else had a question? Chairman Clemens? Recognize.
I just find it hard to believe that we're going to deny this benefit to veterans who served our country and our state over some procedural ridiculousness. I mean, she's committed to making this amendment. We're all on the full committee, and we can vote for or against it when it gets there. I would hate to deprive the veterans who have been honorably discharged from the U.S. military and the National Guard and Reserves over some procedural snafu and try to compare it to the last piece of legislation, which is wholly an entirely different issue. So that's it, Mr. Chairman.
Chairman, this is not an up and down vote on the bill. I'm planning to co-sponsor this. She spoke with me about it. I think a lot of veterans are going to co-sponsor this. The situation that we find ourselves in is that we have made rules in this committee that we will not take untimely filed amendments. We will not take verbal amendments. We just sent another freshman away that had an amendment that we probably could have fixed verbally, or an amendment that we could have easily moved on to full committee, but it's not the policy of this committee. And sometimes when your bill gets put on notice for the final calendar, this is the situation that you find yourself in. And so, as supportive as I am of this bill, and sponsor has mentioned to me, I think this is going to move forward next year. I plan to support it, but it will need to be amended, and it will need to be amended with a timely filed amendment. So we have a motion and a second for the second calendar of 2026. All in favor say aye. All opposed say no. The ayes have it. If you want to register your vote, you can with the clerk. And so, members, that brings us to item number 9. That's House Bill 1290 by Representative Powell. Representative Powell, you are recognized. Do we have a motion and a second? We have a motion. We have a second. This bill. We have a second. All right. So let's see. That's House Bill 1290. I see no amendments, so you are recognized under your bill.
Mr. Chairman, let me reset just a minute and say, it was said on the floor the other day, somebody said this is one of the worst bills they've ever seen. This is one of the best bills you've ever seen. It's the Policy Act. So we know in this state, a lot of times we set up these mega sites, oftentimes for business. What this bill would do, it would set up the first mega site in the country for arts, entertainment, and media. And why is this important? It's important because our state is gifted. We've got such talented, creative people in this state that people all over the country and people all over the world are coming to the state of Tennessee to tap into that creativity. I tell you, I bump into somebody every single time somebody represents Nashville who has moved here from California. They've come here from Hollywood, and they have set up shop. There are production companies that are growing here. So what I'm hoping to do is create, again, the first arts, entertainment, and media mega site in the country. This could be coming to your district. I'm not specifying where this goes. That's up to the Department of Economic and Community Development to decide where this would be. But, Mr. Chairman, the possibilities of this, the ability to have a site like this bring and foster creativity, innovation, all the different things would be a huge economic boom to the state of Tennessee. We know that people are looking for more places around the country. You look at our infrastructure, our climate, all the other things. The reasons why Hollywood was even established in California now are the same reasons why people are interested in Tennessee. So I'm hopeful. You look at a person like Walt Disney, who was successful in building Disneyland and then took it to a much larger scale with Disney World in Florida. I hope you will support this and create the Policy Act, create a mega site so that we can be the place for creativity and innovation the rest of the country.
Members, you've heard the explanation, and sponsor, it does look like we have someone set to testify. Do we have Cameron Snow here from ECD? So we're going to go out of session, sponsor. And Cameron, you are recognized. Just make sure your light is on before you start talking, and state your name for the record.
Thank you, Mr. Chairman and committee. My name is Cameron Snow. I'm a legislative liaison for the Department of Economic and Community Development. ECD is well-versed in fostering business growth and innovation, but this bill extends beyond our purview, requiring expertise in film production infrastructure, performing arts venue management and construction, advanced media technologies, and public-private partnership structuring for fundraising for the mega site. This also requires ECD to be in charge of land acquisition for 2,000 continuous acres in the state of Tennessee, construction and infrastructure of the site, governance and management of 86 employees, and training and workforce development programming, and a center at the site, all of which is beyond the scope of our department at the moment.
All right, Mr. Snow, we appreciate your testimony. Members, we are out of session. Does anybody have a question for Mr. Snow with ECD? Chairman Clemens, you're recognized.
Thank you, Mr. Chairman. What's the function of ECD? What's the goal of ECD and your function within state government?
Mr. Snow, you're recognized.
To foster business growth and help innovation, help communities grow through grants and programming.
Chairman Clemens, you're recognized.
Thank you, Mr. Chairman. That's exactly, I think, what this legislation does. So I look forward to the Department of ECD prioritizing things like this that will generate tremendous amounts of income and revenue and take advantage of the natural talent and resources we have in the state of Tennessee and with which we're blessed. So I'm very excited that ECD is willing to fulfill its mission to the people of Tennessee and endorse this idea. Thank you.
Members, we're still out of session. Does anybody have a question for Mr. Snow? If not, Members, we're going to go back in session. And Representative Powell, you are recognized on your bill.
Thank you, Mr. Chairman. The good news is I'm somebody, I know the big lights, I know the big stage. I am the expertise, nothing but sunshine and bright lights in Tennessee. If you'll pass the Policy Act, I'd appreciate it. Thank you.
All right. All right, members, do we have any more questions for the sponsor? He's too cool. If not, let's go ahead. Members, we're voting to send House Bill 1290 to full commerce. Madam Clerk, if you'll open the board up. Has every member voted? Does any member wish to change their vote? Madam Clerk, take the vote.
Mr. Chairman, you have 3 ayes, 7 nays.
House Bill 1290 fails. Hey, but you look good doing it, Representative Power. All right, members, that brings us to item number 10, and that's House Bill 542 by Chairman Vaughn. We have a motion, we have a second, and Chairman Vaughn, we have, looks like an amendment on there. What drafting code are you showing?
5790, Mr. Chairman.
Mr. Chairman, I'm showing a different drafting code.
You got 5790. If you, Mr. Chairman, do you have 4176?
I do have 4176 is what I'm showing.
All right, let's deal with 4176, shall we?
All right. Can I get a motion and a second on the amendment? We have a motion, we have a second. Chairman, you're recognized on that amendment, drafting code 4176.
Thank you, sir. Did we get it adopted? Okay.
Put it on there.
Yes, I would like 4170.
Put amendment drafting code 4176 on House Bill 542. All in favor say aye. All opposed say no. The ayes have it. Sir, your bill has that amendment on it, and I have now learned about the second amendment and have that. Do you want to put that on now too?
Yes,
or?
please.
Okay.
5790, yes, sir.
Okay, we have a motion and a second on amendment drafting code 5790. Do you just want to go and put it on there too, Chairman?
Yes, sir. It does delete.
Okay. All in favor say aye. All opposed say no. The ayes have it. Sir, your bill is duly amended, and you are recognized for explanation.
Thank you, sir. This is a bill that our utilities and our everybody from gas to wastewater to electric and all forms of electric providers. This bill affects them, and I have to say that when they weren't too wild about it when it first came out, and I appreciate them taking the time to invest in many a conversation in my office and over the phone, and we finally got to a point that we understand each other. This is a provision that allows for individuals to self-build their infrastructure. This is part of a slate of bills I've brought forth this year that try to deal with why are we paying more money than we should just because things have always been done that way. And so what this bill would do would be that utility companies would have to have a provision that they allow a qualified contractor to be able to provide infrastructure construction under the direction of a third-party engineer. And you might say, oh, I don't know about that. But when you think about it, whenever we have a large storm, tornado damage and such, you see a lot of trucks rolling the interstates from out of towns, and these are private contractors that come in and perform these duties. And so, and in many of these cases, water and wastewater plans around the state are done this way anyway. So what we're doing is we're taking this process and expanding it to the outside, to all contractors and all utilities in the state. My hope is two things. Number one, that it brings transparency to cost structure for people with regards to their utility costs. But in the same vein, I hope that it allows the utilities to be able to manage their staffing to the point to where they become more of a maintenance and operation crew rather than capital expenditure, and hopefully that'll help keep rates down. And so like I said, we've done quite a bit of work of this over the last 4 to 6 weeks, and I would appreciate your support on it, and I stand open for any questions.
And Chairman Vaughn, we do have someone here to testify, and so we're going to go out of session and invite up Mr. Anthony Wheeler. Is there an Anthony Wheeler here? We're not going out of session, Chairman Vaughn. Do we have any questions for the sponsor on this bill? Chairman Clemens, you recognized.
Thank you, Mr. Chairman. And sponsor, Chairman, this is one of the most interesting fiscal notes I've ever read. There's not a single dollar amount on here that's highlighted, and it certainly doesn't say not significant, so I don't know how you pulled this one off. But we're not the Finance Committee, but the issue here is the significant impact and increase in expenditures for utilities that could be passed on to ratepayers to help those utilities cover those costs. That's a real concern of mine. Can you speak to that a little bit?
Chairman Vaughn, you recognized.
Yes, sir. I would hope that this would wind up I think this would be a savings to utilities because they don't have to staff to cover these installs, that they can better. I know that MLGW, the utility in Memphis, is trying to roll out a plan like this, and one of the features that the director of MLG&W has expressed is the fact that he can have his crews available to turn power back on and to do maintenance work rather than build out new subdivisions. And my thoughts with that is that this provides a methodology, and all of these contractors have to be approved. Their systems have to be tested. The infrastructure that goes in, I'm hopeful, will be less expensive than what some of these existing utilities do. And I'm hopeful that it winds up in a cost savings for the customers, because that's who it is that I believe this should benefit the most.
Chairman Clemens, do you have anything?
Thank you, Mr. Chairman. And I'm looking at this and referencing Article 2, Section 24 of the Constitution, and what we're doing to impose increased expenditure requirements on cities or counties and utilities. And, in this fiscal note points this out, it result in a significant impact to revenue and increase in expenditures for utilities. And utilities may increase rates if needed. And so I'm concerned about these expenditures that are identified in here being passed on to ratepayers. And since we're all trying to lower costs, we got rising costs across the state of Tennessee. Working families are struggling, and to the extent we'd be passing something that we're not covering the cost of at the state level or sharing in the cost in violation of that constitutional provision and passing on more cost and higher cost to ratepayers and consumers, that's of concern to me. So thank you, Mr. Chairman.
Chairman Vaughn, you recognized.
From looking at to my good friend from Davidson County, when I look at the back page of this fiscal note, I see that it's based on information provided by the Tennessee Association of Utility Districts, who were in opposition to this bill up until I took the amendment language that was provided to me. So maybe I should file this new amendment, and we'll see if those concerns get assuaged.
Chairman Clemens, you're recognized. Turn his microphone on. There we go.
Thank you, Mr. Chairman. I'm looking at this fiscal memorandum with regard to the amendment 4176, which I think is the one we put on. So I guess if they didn't consider it when they made the fiscal note for the bill as amended, as it says it does, that's on them. Thank you.
All right, we've got some more folks on the list here. Next up is Chairman Lafferty. You recognized.
Thank you, Chairman. And just trying to clarify when I was reading through this earlier, I thought that I read that we were going to have outside inspectors looking at the work that was being done. Is that still in this bill?
Chairman Vaughn, go ahead.
The utilities have a right to inspect and test themselves if they want to. That's what this does. Is this provides they have the ability to inspect, they have the ability to test, and also the installing contractor, they can require up to a 1-year warranty on the work, as well as have performance and payment bonds on the work itself. So I believe that the public's adequately protected if that's where you're going with it.
Chairman Lafferty.
Thank you, Chairman. Yeah, I was curious if we get in situations where a developer continues to use the same inspector over and over, that a cozy relationship might develop. We had something like that happen back before the housing bust. There were a number of people around the state, one in my area that I know of specifically, the appraiser of choice, if you will, that folks like to lean on to get the approvals that they wanted. And I was just maybe concerned that if there was too much comfort with a particular inspector, that might be the case, and maybe if there was some sort of rotation or something involved.
Chairman Vaughn, you recognize.
I'm misunderstood your question to begin with. The utility who is going to be accepting these system expansions are the ones who can provide the inspection. So before they own it, because these utilities will be dedicated, what will happen is that let's say that we've got a new subdivision going in. The developer, 9 times out of 10, will get a quote from the local utility because they should be able to do it cheaper. But in some parts of our state, the local utilities are not transparent with their costing. They're terribly slow in scheduling. And in this case, they may be incentivized to hire out their own contractors. Well, that utility can still inspect, still test, still review that, even if they are not the ones doing the work. And that's common in this industry. There's a requirement for water and wastewater that we put into state statute that cities are allowed or must inspect sewer and water systems before they accept them. And so that's the same concept just being applied to different utilities.
Chairman Lafferty, you had enough, or you want a little more?
Yeah, no, thank you for clarifying that. I was a little confused on the way that everything interacted there. Thank you, Chairman.
Leader Camper is next on the list.
Thank you, Mr. Chairman. Chairman Vaughn, it appears that this, if I'm on the right amendment, 4176, that it is requiring this to be done and not giving an option for them to do it. So is this a mandate we putting on local utilities to actually use these outside organizations, companies to develop these plans, and then if they don't respond to it in a certain amount of time, it could cost us money?
Chairman Vaughn, you recognize.
Leader Camper, they're required to have a program that allows someone to do this. It is, my expectation is that very few people, I would imagine that with most electric co-ops, that there would be zero incentive for someone not to hire the co-op to install this. But let's say that a user or a developer in eastern Shelby County is relying on MLG&W. And MLG&W takes years, over a year, to design and schedule the install, and then the install takes several months after that, whenever had this person known that if they had been an option for them to get out of it. And you know, when it comes down to it, if there's a lot of demands placed on the utilities because they have to be in different places, I'm not saying that they're not doing productive work during that time. But what this would do is this would allow utilities to provide better service with supplemented labor forces that are paid for by someone else. That's all we're trying to do here.
Leader Camper, anything else?
That answered my question.
All righty. Looks like next on the list is Representative Barrett. You recognized.
Thank you, Mr. Chairman. Chairman Vaughn, we haven't had a chance to talk about this bill before you were out sick. I received some correspondence from utilities in my district, particularly the Water Authority of Dixon County. That's a regional water authority. They work in 3 different counties, and so they've got some serious concerns about several different parts of the bill. Particularly, there's no prohibition against self-inspection in this bill. It doesn't limit in rural counties where there may only be one engineer that's qualified to do this third party, and that engineer is also the engineer for the developer on the project. There's nothing in the bill that prevents that. Obviously, as well, with the limit of $1,000 on the fee, that is kind of putting all utility projects into one lump sum, and as you well know, every project is different and the complexity of them are also different. And so there's a lot of concern that's been expressed to me. I won't be able to vote for this today. If it does move on to full committee, I would like to get with you to try to work through some of that if we can.
Chairman Vaughn, you have anything?
I'm offering suggestions, and you make decisions, sir.
All righty. Looks like we have Representative Burkhart.
Thank you, Chairman. As someone who does this on a daily basis, it's not like, and Chairman Vaughn can correct me if I'm wrong, that the utilities put these in themselves. They are hiring private companies to do the work already. All this is doing is, but they have a line of work that's already out in front of them. All this is allowing, if I'm understanding the bill correctly, for the contractor, developer to hire a contractor, someone, and I'll just pick electric because that's what we're talking about, to put that in. And water and sewer and all those utilities are put in by the private contractor, by the developer anyway. This is not something that's put in by the municipality. So we're already doing the water and the sewer, the drainage, all that's being put in by private, and the electric's being put in by private. It's just according to who's hiring them. So I think I'm saying all that correctly, and I 100% support this bill, and it makes it better and cheaper on everyone involved. So thank you.
All right. Do we have anyone else on the list? I don't see anyone. So, members, we are voting to send House Bill 540. Oh, wait a minute. Leader Camper. Okay, you're recognized. Go ahead.
I wanted to ask this question. We voted on the First Amendment, the 57 something, and then the Second Amendment. So are we just adopting the Second Amendment, or did he rewrite it?
Chairman Vaughn, you recognize.
Which number are we voting on?
Thank you, Mr. Chairman. 5790 rewrote 41. They were having trouble finding the drafting code, and so.
Yeah, so members, just to clarify, 5790 is the amendment we had adopted. It will rewrite the bill, and we are voting to send House Bill 542 as amended to full commerce. Madam Clerk, if you can open up the board, members, place your vote. Has every member voted? Does any member wish to change the vote? If not, Madam Clerk, take the vote, please.
Mr. Chairman, you have 7 ayes, 2 nays.
All right. Congratulations, sponsor. House Bill 542 passes. It's on its way to full commerce. Good luck in that committee. Members, that brings us to the heel of the committee, and this is our final calendar. So as we wrap up today, I do want to thank some folks. I want to thank Sergeant at Arms Tony Townsend. Appreciate you, Tony, for taking care of us in here. Our attorney, Loving Middleton Dunn. And Matt King for backing her up in here. We appreciate both y'all and your legal minds here. And our research analyst, Mr. Alex Perry. This was his first year, and he did a fantastic job. And my legislative assistant, Mr. Joey Barnett, right here to my right. And so appreciate all of you guys in committee. It has been a privilege to serve as your chairman this year. And so this concludes our business for the year. So yes, he rolled that one. He took it off notice. Yep. So, members, this is our final meeting of the year. So this concludes our business for the year. This meeting is adjourned, subject to the call of the chair.